Oh, yay, oh, yay, oh, yay. This Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, and welcome everyone to the February call of the docket of the Tennessee Court of Criminal Appeals here in Nashville, Tennessee. I want to introduce the judges that will be your panel today from Kingsport, Tennessee. On the screen to your right and my left, Robert Montgomery, and on your screen to the left, but to my right, Judge Robert Wiedemeyer from Nashville, Tennessee, by way of Clarksville. I'm John Everett Williams from Huntington, Tennessee. Mr. Clerk, if you would go ahead and call the case, I'll let you go today. Thank you.
State of Tennessee versus Riley Christopher Wilburn.
Attorneys, this argument will proceed in the same fashion as if we were in person. We want to thank as the judges, we want to thank the clerk's office, Jim Hivner's office, as well as the LC office and the staff there for making this possible. And we very much appreciate you participating in this particular matter. In this particular form, it allows us to continue our work. It allows you to get your clients' cases heard in a prompt and timely fashion, we hope. And whatever trouble you had to go through to be here this morning, we appreciate your efforts and being with us, and welcome. With that, each side is given 20 minutes. You may reserve time the appellant may for rebuttal, and they should do so now after introducing yourself, Mr. Colley.
John Colley for the appellant Riley Wilburn. We would be reserving 5 minutes, please, for any rebuttal.
And I'll help you do that.
Thank you.
Yes.
Gentlemen, Mr. Wilburn was charged in a one-count indictment with DUI by under two different statutory schemes, both of them under 5510-401. Subsection A1 makes it illegal to operate a motor vehicle on the public roadways of Tennessee while impaired. And subsection A2 makes it illegal to operate a motor vehicle on the highways of Tennessee while your blood alcohol is 0.08 or greater. These two statutory provisions were joined in one count with the disjunctive or. And relatively early on in the process, Mr. Wilburn moved to dismiss the indictment because it was duplicitous. That motion pretrial was denied, and Mr. Wilburn renewed his motion to dismiss the indictment and raised other objections to the jury instructions and the jury verdict form during trial, all of which were overruled or denied by the trial court. The state, true to their indictment that they brought, proceeded both in opening arguments, proof, and closing arguments to argue both statutory schemes to convict Mr. Wilburn. Their proof included not just proof from the arresting deputy about field sobriety tests and what they meant in terms of impairment, but also testimony from the TBI lab technician, Melissa Klingman, about his blood alcohol when the blood was drawn approximately an hour after he was stopped. And using that proof, the state then argued in closing both routes to a conviction, and didn't at any point make an election of any type. The jury verdict form, like the instructions, set the stage for a patchwork verdict. The verdict form simply convicted Mr. Wilburn of DUI, found him guilty of driving under the influence of a drug or intoxicant, without any reference to impairment or the 0.08 threshold blood alcohol. What what has happened is there's absolutely no safeguard in place in this jury trial to ensure unanimity of the jury verdict. Nothing. And I know the state chose not to really deal with that in its reply brief or response, but that's the big problem here. Mr. Wilburn certainly believes that if you follow Isabel, all these other cases since Isabel, including last year in Doty, which makes this, we think is almost spot on, that these are two separate and distinct statutory offenses, and they simply cannot be included in one count. And the unanimity of the verdict is one of the problems that duplicitous indictments create. And here we don't know which jurors voted for Mr. Wilburn having violated subsection A1 versus A2. And without any type of an election, without the appropriate verdict form, without the appropriate instructions, the instructions given by the court simply track the pattern, which we would submit the pattern anticipated giving one or the other when it came to the fourth element, not both, joined by the disjunctive or. And there's just not any way to fix this based on the way this all developed, based on the way the case was indicted, the way it was argued, the way it was proven, and the way it was decided. And
Mr. Colleague, can I ask you the Isabel case and the Gillum case that you're citing? In your brief, you recite that the prohibition against duplicitous indictments is to ensure the defendant is provided adequate notice of the allegations. That's the first one. Are you claiming you didn't have proper notice that these two alternative theories were going to be sought to get a conviction?
I don't think the notice issue, I think there's a total of three, if I remember correctly. Three problems that duplicitous indictments cause. I think this is more similar to the Doty case from last year, where the elephant in the room is a lack of or no guarantee of unanimity of the verdict. I think that's the third factor under Isabel and Gilliam.
So is that not resolved by a jury instruction form or the jury form more so than what the indictment alleged?
It could have been. That would have been a start, Judge. That would have, but that's not what happened. And like Doty said, I can't remember who wrote Doty, but like Doty said, every defendant in Tennessee is entitled to not only a unanimous verdict under our Constitution, but the correct instructions from the trial court. And we objected on the instructions. We objected on the verdict form. We did everything we could respectfully to try to fix this. And no one else, it appeared, was interested in addressing it. And I agree with you. It possibly could have been cured, possibly with the correct instruction. But the instruction was straight out of the TPI, which gives alternatives to the court depending on which count and which avenue the state's traveling under. The trial court just gave both of them, joined by or once again, as if half the jurors could vote on one way and half the jurors could vote on the other. And I know that this is awful quick, but unless there's some other questions about the proof or the proceedings or anything else about our argument, I'll reserve the rest of my time.
Mr. Cawley, the briefness of your argument does not in any way diminish its importance. And it shows the sign of a very prepared and good lawyer, too. Thank you.
Thank you.
General?
Good morning, Your Honors. May it please the court. I'm Austin Watkins, appearing on behalf of the state of Tennessee. Your Honors, in this case, the indictment permissibly charged alternative means of DUI in the same count. Therefore, the trial court correctly denied the motion to dismiss the indictment, and the state would ask you to affirm the judgment. Your Honors, I think you're probably aware of this. Mr. Colley helpfully appended the indictment to his brief. So if you've got that, you can flip and see the language if you need it. We quoted it on page 5. And it's a single count indictment. And if you read it, it kind of has all these alternative ways you can commit DUI connected with ORs. And that is one of these things that there's, the parties agree on the law, Your Honors. The Tennessee Supreme Court recently in State versus Jones explained that an indictment is duplicitous if you charge more than one offense in a single count. And the three purposes that have been alluded to during the appellant's argument, it provides adequate notice, prevents double jeopardy, and ensures jury unanimity. However,
General, can I ask a question?
Yes, Your Honor.
Isn't DUI by being under the influence and DUI per se, are they not separate offenses?
No, Your Honor. The state's position is that they are alternative theories of the same offense. And so if you look at the DUI...
Well, let me ask, I understand what you just said. Let me follow up, because I used to prosecute DUI cases a long time ago, but I thought there was a reported case, I think it was Conway, where there were two separate counts. One was DUI under the influence, and the other was DUI per se. The jury found him not guilty of DUI under the influence, and it was a hung jury on the DUI per se. And the court of criminal, and they continued to prosecute again, and was found guilty under the DUI per se. And I thought Conway was the one that said that those were two separate crimes because they had separate elements. And so it was not double jeopardy, even though he was found not guilty of DUI under the influence, the state could still proceed under DUI per se. So does that not make them two separate crimes with separate elements?
Your Honor, I'm unfamiliar with the Conway case. I
think it's in your brief.
Is that the one? Is that a CCA case, Your Honor, or is that a
2001 State v. Conway?
I mean, is it a Tennessee Supreme Court case, or is
Court of Criminal Appeals? It's reported, but it's Court of Criminal Appeals.
State versus Cooper? I've got it here.
I thought I saw it in your brief. Maybe I misread your brief.
I'm sorry. No, I don't believe it is, Your Honor. I've got it here, and I wish I could speak to it. But to address your issue, Your Honor, that question about double jeopardy, we cited this Cooper case where the Supreme Court has said you have to merge convictions for both DUI per se and DUI by impairment. So
I agree with that.
It is one offense. So
but the same thing would be true with sale of a drug and delivery of a drug. Those are separate crimes, but if you're found guilty of both, then they have to merge.
That's right. Yes, Your Honor. And so, but in this, the state's position is that this is more similar to first-degree murder, that this is similar to felony murder and premeditated murder. And so the case law says you can charge those in one count of an indictment. And so this is a similar situation where it's one offense, but there are alternative means of guilt. So the state can prove either impairment or it can prove, BAC. And so
doesn't there have to be, but so you're saying there doesn't have to be jury unanimity?
That's correct, Your Honor. So if there's one offense submitted to the jury and it could be either theory, there's proof of both means. That
even though they may be separate crimes, you're saying?
Well, no, Your Honor. If they're the same crime, the state's position is it's the same offense. There are two alternative means to commit the offense. So in this case, for example, if the jury was instructed on DUI by impairment or DUI by blood alcohol concentration, there's no jury unanimity problem because at the end of the day, all of them are agreeing that he committed the offense of DUI in this particular case. It's one charge of DUI. And so it's six.
Well, wait just a minute. On what theory did they convict?
The record doesn't say, but the state's position is it does not matter. So unanimity only comes in play if there's two separate offenses, two completely different.
In essence, when you're giving the jury instruction, you should give the jury instruction in general on offenses, and if 6 vote that he was guilty without a blood alcohol and 6 vote that he was guilty with a blood alcohol, then he is guilty.
Yes, Your Honor. So it would have been clearer to charge them with both options, but we didn't brief this issue because the briefing focused on the indictment rather than the unanimity issue specifically, Your Honors. But I believe my understanding of the law is that you have to have unanimity on one offense. And so if half of the jury believes he's guilty by one way and the other half agrees he's guilty by the other, they're still all unanimously agreed that he committed the one offense. And so, Your Honors, that is kind of the theory underlying why it's okay for, it's not duplicitous for an indictment to have both premeditated and felony murder alternatives in one count. I mean, those two theories have separate elements. So it is still one murder, but there's a different element for premeditated murder and there are different elements for felony murder. But this case law is clear on that those issues or those theories can be cited in one count because they're alternative theories of murder. It's not two separate different crimes, two separate crimes that are being charged in that situation. And so
we're one of the few states in the nation that put felony murder and first degree murder in the same statute. Very few states do that. And I am not just racking my little brain. I cannot remember a case where I thought it was possible that 6 could find felony murder and 6 could find first degree premeditated murder and those convictions stand. I'm having a hard time understanding how you ever have a unanimous verdict when they can, in other words, you cannot be convicted of DUI per se, as they call it, without a blood alcohol. You have to have a blood alcohol. You can be convicted of DUI by impairment without a blood alcohol. So there's evidence and elements totally different. So what if there wasn't a blood alcohol and people voted per se, and we knew we would throw that out? How would we ever know if there's not a jury form that says pick one or the other? That's a little bit of a problem with me today.
I understand that, Your Honor. I think the state believes that under this situation where, it could have been committed by one of two ways, if they all agree, even if they're not unanimous on which means, they're still unanimous that he was guilty of DUI. And that's consistent with the statute. If you look at TCA 5510-401, it has an umbrella paragraph that sets forth some shared elements. And then it says 1, 2, or 3. And it says, under the influence with impairment. And then it says alcohol concentration is over 0.08, and then it has the commercial BAC. So it's one offense that lets you, either way you get there is fine. And so the problem with unanimity is when you don't have it's unclear from the record whether the jury found on multiple offenses. For these sex cases, for example, we have a lot of problems with unanimity issues in child sex offenses. Sometimes, so you're like, if it's not clear whether the jury is finding the same incident constituted an offense, that's a unanimity problem. But if the jury can sit there and go, well, we don't fully agree on, 6 of us think he was impaired by his behavior, but we just have a problem with the test for some reason, or the other 6 think, well, we believe the test, but we don't believe the field sobriety evidence. At the end of the day, there's still a unanimous verdict as to him being guilty of one offense of DUI. They all agree he was guilty of DUI at the end of the day. And so, Your Honors, that is the state's position as to why the indictment is not duplicitous if it is charging those alternative means in the indictment. And that's the primary issue, is whether the indictment is fatally flawed. So if we want to move and try to look at the jury verdict form, we can, the state's happy to provide supplemental briefing on any problem with the jury verdict form with regard to unanimity. And because the state's brief didn't go into that very much. But essentially, the parties agree on the law with regard to the charging, the duplicity. It's, you can't charge two separate offenses in one count. You can charge alternative theories of alternative means of guilt. And that's also, Your Honors, that is stated by statute in Tennessee Code Annotated 4013-206. When the offense may be committed by different forms, by different means, or with different intents, the forms, means, or intents may be alleged in the same count in the alternative. And that is what happened here. And so this is not a situation where, as like the Doty cases, Isbell cases, these cases that have found duplicity that the appellant relies on, those cases cited completely separate offenses, not alternative means of committing the same offense. It was, child abuse is one offense, child neglect is a different offense, and they're set out differently in the statute. The same with the the possession cases, possession with, intent for this or possession with intent for that. They're older cases before I believe that statute was changed. And so those cases are distinguishable from what we have here, where the DUI statute says DUI can be committed by one of two means. It's okay to charge both the means in the indictment. And that is the narrow challenge of the appellant's briefing, is that indictment, the way it was charged, both of those theories in the same count, that was duplicitous. And so the state, there's no case law for DUI on this particular point, but the state believes it is much more analogous to the felony murder situation, where there's one murder and alternative means, and the case law says it's okay for those to be charged in the same count. And so that is the state's position, Your Honors. And I understand the unanimity concern. And so if the court thinks it would be helpful, I am happy to try to find that case law that would say, and under these circumstances, it would be permissible to do that. I can't give you a citation right now. That's my recollection from just experience. So the state would ask you to affirm that at the end of the day, when it comes down to it, the jury has the proof here for two different ways to get to one offense. It would have been desirable, I guess, if it would be better for them to be charged separately. But at the end of, the case law just doesn't require that to happen.
Thank you, General. And I'm going to ask my other colleagues, but after we hear from Mr. Colley, if they wish to have a supplemental briefing on this case, so y'all can be thinking about that. Mr. Colley, you may want to weigh in on that issue as well. Would supplemental briefing help in this case?
Judge, it may help the state since they didn't address unanimity. I don't think you can separate unanimity out from the duplicity issue, frankly. If they offer them any opportunity, I think I more or less challenge them to address that issue in their argument. And if they need an opportunity to go do some research, I welcome. I think the more we know about the case law, the better it is.
Well, could I ask you whether you agree with their statement that they could find six could find one way and six could find the other, and we have a unanimous verdict?
You can ask me, but I won't ever agree with that.
Well,
that's the opposite of unanimous, Judge. When you've got two separate statutory schemes, just like child neglect and child abuse are in one statute in Doty, these are two different ways to get to DUI. And as you pointed out, they're done differently with different elements. And if we learned anything from Conway and State versus Cooper, where the Supreme Court relied on Conway, we learned that if you do this right, and that is do a separate count for each avenue of attack, the jury can acquit DUI on count one and get hung up on the other. And the defendants got to go back and face retrial on the one they got hung up on. Now, if you want to buy my adversary's argument, if this is just all the same crime, if they come back not guilty on DUI under one, there shouldn't be able to be a retrial because they came back not guilty. And we can do felony murder and premeditated murder all in one count, but there are safeguards along the way, which they're not present in this case. There are safeguards along the way in those trials to make sure we have a unanimous verdict. There's instructions done differently to address that issue, and I would submit there's a jury verdict form done to address that issue. None of that was done in this case because no one involved, other than Mr. Wilburn, wanted to really give any credibility to this argument that this is a problem and this is just not the way it's done. That's all I have.
Thank you, Mr. Colley. I'm inclined to allow the state to supplement an argument and let Mr. Colley have 30 days to hope he can do it in 15, but will allow 30 days for him to respond to the state's supplementation on this issue of unanimous verdict and in the context that we've argued today. Judge Wiedemeyer, may I ask you what your feelings are in that?
Yes, I totally agree. I think that's the issue that concerned me as well. And General, I'd appreciate any research or additional briefing that you can provide. Particularly, it seems to me that if you look at DUI as one offense, if I were on this jury, had been on this jury in this particular case, it's conceivable that I could have voted not guilty of DUI based on the fact that I didn't think the blood test was adequate, and guilty of DUI based on the impairment. And so I'm basically, as a juror, I'm voting guilty and not guilty of the same offense. And maybe that's okay, since you got 12 people who apparently said one way or the other, we ended up at DUI. But I do think this is the issue in this particular case, and I'd appreciate anything you might add in a supplemental brief.
Judge Montgomery, you have a position?
I agree with the supplemental brief idea too.
Okay, we always can use all the help we can get in the research and the law. This case has a little age on it, so General, I would ask that you get your research together in 30 days and get it to us. And Mr. Colley, I appreciate you responding within 30 days after your receipt. And thank you,
Yes,
gentlemen.
sir.
Thank you, gentlemen, for your presentations today. They were very well done and an interesting issue, to say the least.
Thank you, Your Honors. And if I'm wrong, I'll point that out too. So if there's nothing there to support it, we may need to do a concession. So, I mean, we want the court to get it right. So,
Well, we appreciate and thank both parties have that attitude, General. We sure do. Thank you.
This honorable court is now in recess until 11 a.m.